Remedies of a party declared in default. The fact that a defendant has lost his standing in court for having been declared in default does not mean that he is left sans any recourse whatsoever. After notice of the declaration of default, but before the court renders the default judgment, the defendant may file under oath a motion to set aside order of default or motion to lift order of default. The defendant must properly show that his or her failure to answer was due to fraud, accident, mistake, or excusable negligence. The defendant must also have a meritorious defense. Okay, again, the defendant in default may at any time after discovery thereof and before judgment file a motion under oath to set aside the order of default on the ground that his failure to answer was due to fraud, accident, mistake, or excusable negligence, and that he has a meritorious defense. Okay? The motion to lift order of default requires a verified motion showing fraud, accident, mistake, or excusable negligence, and a meritorious defense. In such a case, the order of default may be set aside on such terms and conditions as the judge may impose in the interest of justice. Also, a petition for certiorari may also be filed if the trial court declared the defendant in default with grave abuse of discretion. Conditions for a motion to lift order of default. The defendant's motion to set aside order of default must satisfy three conditions. First is the time element. The defendant must challenge the default order before judgment. Second, the defendant must have been prevented from filing his answer due to fraud, accident, mistake, or excusable negligence. Third, he must have a meritorious defense. Rule 9, Section 3B gives an exclusive list of only 4 grounds that allow for relief from orders of default. Moreover, these grounds, extrinsic fraud, accident, mistake, and excusable negligence, relate to factors that are extraneous to a defendant, that is, grounds that show that a defendant was prevented by reasons beyond his or her influence from timely filing an answer. Okay, what are the requisites to grant a motion to lift order of default? Consistent with Rule 9, Section 3B of the 1997 Rules of Civil Procedure, the remedy against an order of default is a motion to set it aside on the ground of fraud, accident, mistake, or excusable negligence. However, it is not only the motion to lift order of default which a defendant must file. As the court emphasized in the case of Aggravante versus Patriarca, to the motion to lift order of default must be appended an affidavit showing the invoked ground, and another, denominated affidavit of merit, setting forth facts constituting the party's meritorious defense or defenses. The need for an affidavit of merit is consistent with Rule 8, Section 5 of the 1997 Rules of Civil Procedure, which requires that in all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. Okay? In the case of Montinola Jr. versus Republic Planters Bank, the Supreme Court noted that the 3 requisites that must be satisfied by a motion in order to warrant the setting aside of an order of default for failure to file an answer are: Number 1, it must be made by motion under oath by one that has knowledge of the facts. Number 2, it must be shown that the failure to file answer was due to fraud, accident, mistake, or excusable negligence, and there must be a proper showing of the existence of a meritorious defense. Consistent with Aggravante, it is through an affidavit of merit that a defendant seeking relief from an order of default shows that the failure to file answer was due to fraud, accident, mistake, or excusable negligence. The Supreme Court held in one case, or in the case of Spouses Manuel versus Ong, that the Court of Appeals noted that the Spouses Manuel's motion to lift order of default was not made under oath. It added that the motion was not accompanied by an affidavit of merit specifying the facts which would show that their non-filing of an answer within 15 days was due to fraud, accident, mistake, or excusable negligence. Failing both in making their motion under oath and in attaching an affidavit of merit, the Spouses Manuel's motion to lift order of default must be deemed pro forma. It is not even worthy of consideration. Certainly, the court held that there is jurisprudence to the effect that an affidavit of merit is not necessary where a motion to lift an order of default is grounded on the very root of the proceedings, such as where the court has not acquired jurisdiction over the defendants. Similarly, there is jurisprudence stating that when a motion to lift an order of default contains the reasons for the failure to answer, as well as the facts constituting the prospective defense of the defendant, and it is sworn to by said defendant, neither a formal verification nor a separate affidavit of merit is necessary. However, the Supreme Court held that in this case, Spouses Manuel failed not only in attaching an affidavit of merit, but also in making their motion under oath. They are, therefore, left without any alternative on which to rest. Their motion is utterly ineffectual. Okay, what is the remedy of a party declared in default after judgment? If the judgment has already been rendered when the defendant discovered the default, but before the same has become final and executory, he may file a motion for new trial under Section 1A of Rule 37. He may also appeal from the judgment rendered against him as contrary to the evidence or the law, even if no petition to set aside the order of default has been presented by him. Appeal is available to the defendant declared in default. To repeat, he or she may appeal the judgment for being contrary to the evidence or to the law under Rule 41, Section 2 of the Rules of Court. He or she may do so even if he or she did not file a petition to set aside order of default. Talking about appeal from a judgment by default. Indeed, a defending party declared in default retains the right to appeal from the judgment by default. However, the grounds that may be raised in such an appeal are restricted to any of the following. First, the failure of the plaintiff to prove the material allegations of the complaint. Second, the decision is contrary to law. And third, the amount of judgment is excessive or different in kind from that prayed for. In these cases, the appellate tribunal should only consider the pieces of evidence that were presented by the plaintiff during the ex parte presentation of his evidence. A defendant who has been declared in default is precluded from raising any other ground in his appeal from the judgment by default, since, otherwise, he would then be allowed to adduce evidence in his defense, which right he had lost after he was declared in default, right? Indeed, he is proscribed in the appellate tribunal from adducing any evidence to bolster his defense against the plaintiff's claim. While it may be said that by defaulting, the defendant leaves himself at the mercy of the court, the rules nevertheless see to it that any judgment against him must be in accordance with the evidence required by law. The evidence of the plaintiff presented in the defendant's absence cannot be admitted if it is basically incompetent. Although the defendant would not be in a position to object, elementary justice requires that only legal evidence should be considered against him. If the same should prove insufficient to justify a judgment for the plaintiff, the complaint must be dismissed. and if a favorable judgment is justifiable, it cannot exceed in amount or be different in kind from what is prayed for in the complaint. Now, what is the remedy of a party declared in default after judgment is final and executory? If the defendant discovered the default after the judgment has become final and executory, he may file a petition for relief under Section 2 of Rule 38. The remedies of a motion to set aside order of default, motion for new trial, and petition for relief from judgment are mutually exclusive, not alternative or cumulative. This is to compel defendants to remedy their default at the earliest possible opportunity. Depending on when the default was discovered and whether a default judgment was already rendered, a defendant declared in default may avail of only one of the three remedies. Thus, if a defendant discovers his or her default before the trial court renders judgment, he or she shall file a motion to set aside order of default. If this motion to set aside order of default is denied, the defendant declared in default cannot await the rendition of judgment, and he or she cannot file a motion for new trial before the judgment becomes final and executory, or a petition for relief from judgment after the judgment becomes final and executory. Also, the remedies against default become narrower and narrower as the trial nears judgment. The defendant enjoys the most liberality from this court with a motion to set aside order of default, as he or she has no default judgment to contend with, and he or she has the whole period before judgment to remedy his or her default. With a motion for new trial, the defendant must file the motion within the period for taking an appeal, or within 15 days from notice of the default judgment. Although a default judgment has already been rendered, the filing of the motion for new trial tolls the reglementary period of appeal, and the default judgment cannot be executed against the defendant. A petition for relief from judgment is filed after the default judgment has become final and executory. Thus, the filing of the petition for relief from judgment does not stay the execution of the default judgment unless a writ of preliminary injunction is issued pending the petition's resolution. Upon the grant of a motion to set aside order of default, motion for new trial, or a petition for relief from judgment, the defendant is given the chance to present his or her evidence against that of the plaintiffs. With an appeal, however, the defendant has no right to present evidence on his or her behalf and can only appeal the judgment for being contrary to plaintiff's evidence or the law. Similar to an appeal, a petition for certiorari does not allow the defendant to present evidence on his or her behalf. The defendant can only argue that the trial court committed grave abuse of discretion in declaring him or her in default. Thus, should a defendant prefer to present evidence on his or her behalf, he or she must file either a motion to set aside order of default, motion for new trial, or a petition for relief from judgment.